Hello and welcome. Before I read Judge Bev's decision denying the defense's motion to recover expert expenses, I wanted to read to you the preservation demand that David Unetti submitted to the Stoughton District Court in February of 2022. So that it's all clear to all of us. So during the last video, you may have heard me say that Judge Beverly Cannone was the one who agreed about the preservation order in February of 2022, but it was not Judge Bev. It was the Stoughton District Court. So, but however, the defense has used this order, this request by David Unetti in previous filings to the Superior Court for the case that Judge Bev is overseeing. So when Judge Bev, during the motions hearing yesterday, when she said she isn't sure and she behaved as if she wasn't familiar with ever having heard from the defense that they wanted everything to be preserved, right? It's such a strange, again, it's the Twilight Zone. It's such a strange argument that the defense has to actually defend their right. They have to defend Karen Reed's right to due process and to avoiding Brady violations by having all the evidence that the prosecution has in their case against Karen Reed. And it's as if Judge Bev is behaving like the defense never asked for all of the evidence. And Judge Bev is behaving as if the prosecution did not violate discovery rules when they failed to submit all of the evidence to the defense team before the first trial. Remember, the defense was still getting evidence from the prosecution during the trial. And it's clear now with these recent court filings that the defense is still getting evidence from the prosecution. You know, in 2024 and in 2025, the defense is still getting evidence from the prosecution, guys, right? So for Judge Bev to be literal here, you know, she's making her decisions based on the facts rather than her full knowledge of the case. Like she should know after seeing these attorneys for the last 2 years, right? She should know that they wanted a bunch of evidence that the prosecution did not turn over, right? Like, I'm just saying, I do not agree with the way she's handling this, but she's relying on the facts of these motions, and she knows she can get away with it because, you know, the defense's motion to recover expert expenses, it did fall short. It fell short, and she knew. She took it as an out, and she denied it. And in my video that I provided yesterday about the motions hearing, I expressed the two issues that I observed from the defense team. But before I get into that, I'm going to read this 3-year-old emergency motion from David Unetti. So it reads, Commonwealth versus Karen Reed, defendant's emergency motion for preservation of evidence. Now comes the defendant, Karen Reed, and hereby moves this honorable court to order the Commonwealth to preserve the following evidence in connection with this matter. Number 1, all notes of any law enforcement official, police officer, and or state trooper of any and all witness interviews, including any notes of anything the defendant is alleged to have said. The defendant is specifically requesting this court to order that such notes are not to be destroyed upon the completion of police reports. Number 2, All notes, any law enforcement official, police officer, and or state, it cuts off, probably state trooper, regarding this investigation. The defendant is specifically requesting the court to order that such notes are not to be destroyed upon the completion of police reports. It's dated February 2, 2022. I'll go to the next page. Number 3, all tapes from any local police department and the Massachusetts State Police regarding this matter, from the first time the police were contacted to the arrest of the defendant. So number 3, pulling away from David Unetti's motion, number 3 is covered. Number 3 includes the footage that was in the DVR system. So back in February of 2022, David Unetti took it upon himself to motion the Stoughton District Court to preserve all tapes from any local police department and the Massachusetts State Police regarding this matter. Okay, guys? That includes everything the Canton Police Department had from January 29, 2022. So just saying, like it wasn't a lie. It was made clear very early on in this case, just a couple days after John O'Keefe was murdered by the people inside 34 Fairview. Just a couple days after that, David Unetti was on it, and he asked that all of the tapes be preserved. Continuing with number 4, all 911 recordings regarding this matter. Number 5, all trace evidence, including but not limited to fingerprints, DNA evidence, blood, saliva, and any other bodily fluids. The defendant is specifically moving this court to order that no exhaustive testing should be performed on any evidence in connection with this case without the Commonwealth giving prior motion to the defendant and allowing the defendant to object. And that's an excellent preservation request to essentially say, like, whatever DNA samples you guys collected, you can't use it all. Not without the Commonwealth giving Karen Reed a proper heads up and giving her the opportunity to object. So not only did David Unetti move this court, the Stoughton District Court, to preserve all the tapes, all the footage, he also said to preserve all the DNA, to not use up all the samples. Continuing. Number 6, all physical evidence, including anything present on or near the defendant at the time, the decedent at the time his body was discovered, anything found at the alleged crime scene. That's really good wording because it was an alleged crime scene, amazing. Like, yeah, the front lawn was not the crime scene because the attack and the assaults happened somewhere else. And everyone following this case is aware of that. John O'Keefe's body was placed on the lawn. The only portion of the lawn that is part of the crime scene is the fact that John O'Keefe was placed out there to finish dying from hypothermia. In that way, the lawn is part of the crime scene. But other than that, the crime, to all of us following this case, everyone who is aware of the facts of the case, we all know that the crime did not happen outside. Continuing. As grounds, therefore, the defendant states that said notes may contain exculpatory evidence to which the defendant would be entitled. See Massachusetts Rules of Criminal Procedure 14A1C. See also Brady versus Maryland. That's the Brady violation I was referring to, guys. The defendant also states that without an order of preservation at this early juncture, the Commonwealth would be held to a lesser standard of preservation, prejudicing the defendant. And then provides more case law. Commonwealth versus O'Neill, Commonwealth versus Heath, Commonwealth versus Williams, and another. And continuing, wherefore the defendant respectfully requests that this honorable court allow this emergency motion for preservation of evidence. And again, it's dated February 2nd, 2022. So David Yannetti and Alan Jackson, during yesterday's hearing, they were correct. And again, Charlie Lynn 143, she remembered, and she reminded us all in the comments section. And this document further proves that there was, in fact, a motion submitted just a couple days, again, after John O'Keefe was murdered. A motion was submitted by the defense team to preserve all evidence, right? So, and we read everything that it covered. So there's really no reason for Judge Bev to, again, behave as if she wasn't aware or she didn't know. It's almost like yesterday, like, just obviously she's corrupt, but it's as if yesterday she was like out of touch with this case. You know, again, she behaved as if this was out of left field. Anyway, but at the same time, the defense should be filing a separate motion with respect to the Brady violations. They absolutely should be filing a separate motion. The motion that they were addressing yesterday was the defense's motion to recover expert expenses. And as I said in yesterday's video, the defense did not bring up the Brady violations in their motion. The defense did not bring up this February 2nd, 2022 motion to preserve evidence in their motion. The defense decided to bring up those arguments during the motions hearing yesterday. So, and as I said in my video yesterday, that gave Judge Bev an out. You know, she was able to say, look, you did not list these arguments in your motion, so I'm denying your motion, you know? And to some who aren't familiar with that process, that's very common, you know? Again, when you file a motion with the court, whether it's civil court, family court, or criminal court, you have to include in your motion everything you're going to argue during the hearing. And it's considered like inappropriate and a waste of the court's time to add on arguments the day of your hearing that you did not include in your motion. Because the whole point of the motion is to prepare the court and the opposing party. You know, it serves the purpose of preparing everyone for what you're going to argue during the hearing, you know, and that's part of the due process, you know, that you're supposed to be able to get a heads up whenever someone's making accusations about you, or whenever someone wants to motion the court and that motion could directly impact you, you know. So anyway, I made this argument during yesterday's video, and that was before Judge Bev made her decision about the motion to recover expert expenses. But I'm going to resume reading these documents before I read her decision. So again, this is still the February 2nd, 2022 motion from the defense to preserve all evidence. It reads, respectfully submitted for the defendant, Karen Reed, by her attorney, David R. Yannetti. And again, February 2nd, 2022. The previous motion from David Yannetti took place in February of 2022, and this one takes place in September of 2022, and it is in the Superior Court of Norfolk County, whereas the previous one was in the District Court of Stoughton. So this motion reads, defendant's motion to renew motions previously filed in Stoughton District Court prior to indictment. It reads, now comes the defendant, Karen Reed, in parentheses, Miss Reed or the defendant, and respectfully moves this honorable court to reaffirm and allow the defendant's motions that were previously filed and allowed in Stoughton District Court prior to indictment in connection with this matter. Specifically, the defendant respectfully moves this honorable court to reaffirm and allow the following motions. Number 1, defendant's emergency motion for preservation of evidence allowed February 2nd, 2022. Number 2, defendant's motion for inspection and independent data retrieval allowed May 6, 2022. Number 3, defendant's motion for preservation of, quote, tower dump, end quote, I think it says dump evidence allowed May 6, 2022. Number 4, defendant's motion for complete file of crime laboratory allowed to the extent that such materials are within the custody control of the prosecutor, May 9, 2022. Number 5, defendant's motion for preservation of Google geofence data allowed May 6, 2022. Number 6, defendant's motion for preservation of vehicle event data recorder evidence allowed May 6, 2022. Number 7, defendant's motion for leave to file further discovery motions allowed May 6, 2022. Number 8, defendant's motion for notice of exhaustive forensic testing allowed May 6, 2022. Number 9, defendant's motion for production of documentary evidence allowed May 6, 2022. And you guys can see from the bottom of the document that Judge Bev B. Cannone denied the motion in October of 2022. And she didn't write any comments, people. She just wrote denied B. Cannone. So you see, guys, in February, David Unetti made the effort to preserve all evidence. And then again in September of 2022, the defense team made the effort to preserve all evidence, but Judge Bev denied their motion. This one is also from September of 2022, and it's defendant's motion to compel discovery. It reads, now comes the defendant, Karen Reed, Miss Reed, or the defendant, and respectfully moves this honorable court pursuant to Mass R. Crim Rule 14 to compel the Commonwealth to provide the following documents and information. Number 1, all documents relating to chain of custody and or the logging of evidence prepared by law enforcement in connection with this case, including but not limited to evidence obtained by the Canton Police Department and or the Massachusetts State Police. Number 2, all 911 call logs and dispatch records for this incident. Number 3, all call logs, tapes, and complete recordings of all 911 calls relating to the incident, including a complete copy of the initial 911 call made by Jennifer McCabe at 6:04 a.m. on January 29, 2022. Number 4 is highlighted. All crime scene photographs and or videos taken in connection with this case, including but not limited to photographs documenting the purported recovery of pieces of white and red plastic outside the residence located at 34 Fairview Road on January 29, 2022 and February 4, 2022, including the metadata associated with these photographs and videos. And there's a footnote. Number 1, the defense has an incomplete recording of the initial 911 call placed by Jennifer McCabe on January 29, 2022 at approximately 6:04 a.m. We are therefore requesting a copy of the entire audio recording of this phone call. Crazy, right? They weren't even given the entire phone 911 call. They weren't even given the entire 911 call. Like, why not? Continuing, number 2, another footnote, on June 10, 2022, the Commonwealth filed the Commonwealth's notice of discovery, which included an itemized list of discovery and materials which were purportedly produced to defense. Okay, so Judge Bev, in this order, it's dated October 5, 2022. It's when she ruled on it. She allowed 1, 2, 3, 4, 5, 12, but she denied number 5, 6, 7, 8, 9, 10, and 14. And then there's something written here, something like counsel may view. I don't know. I can't read it. It's like the doctor writing. Okay. But let's go back to number 4. So, all crime scene photographs and or videos taken in connection with this case, including but not limited to photographs documenting the purported recovery of pieces. So all crime scene photographs and or videos taken in connection with this case. And she allowed it. She granted number 4. But again, this motion pertains to the crime scene. And she also granted number 1. And number 1 is all documents relating to chain of custody and or the logging of evidence prepared by law enforcement in connection with this case, including but not limited to evidence obtained by the Canton Police Department and or the Massachusetts State Police. So I'm just saying, guys, like, she granted this. The point here is, guys, that Judge Bev was aware that there were previous preservation orders, and she received the request in September of 2022 to reaffirm the same orders that the Stoughton District Court allowed. So Judge Bev was aware in 2022 that the defense wanted everything preserved, period. And even if she did not make an order, even if she denied some of their motions, much like she denied all of their motions to dismiss, it's still documented that the defense made every effort to have all that evidence preserved. And so to me, it was entirely inappropriate for Judge Bev to behave yesterday as if it was the first time she was hearing all this. And yeah, 2022 was 3 years ago. Yes, but this is her case. She's the one who did not want to leave this case, right? The defense asked her to recuse herself. And because in Massachusetts, the judge who is being asked to recuse themselves is allowed to decide whether they should recuse themselves, Judge Bev decided she should not recuse herself. So I'm saying she wanted this case. Judge Beverly Cannone wants the Karen Reed case. So if she wants it so bad, why isn't she taking notes? Why isn't she documenting what's going on? Why is she behaving as if the defense team is speaking a different language when she's well aware? She was there for all the times the defense asked for the prosecution to comply with discovery, and the defense asked for the preservation of all of the evidence, including the evidence that was in Canton PD's possession. So I'm saying, guys, the Judge Bev can only get so technical for so long before her story falls apart. She's either extremely out of touch and corrupt, or she's not that intelligent that she can't keep track of all her cases, the cases that she chooses to stay in despite being asked to recuse herself. So let's read her motion that she submitted yesterday. Her decision reads Commonwealth versus Karen Reed. Decision and order on defendant's motion to recover expert-related expenses from the Commonwealth. After hearing and review of the pleadings, the court credits the affidavit of Special Prosecutor Hank Brennan. Paragraph 6, quote, Attorney Jackson expressed concern that the materials may no longer exist on the NVR given the time that had passed since the event. I agreed with him and told him that I had no knowledge whether the materials still existed or were overwritten given the passage of time, end quote. In light of the averment of ADA Brennan and in light of Attorney Jackson's acknowledgement during the hearing that he and ADA Brennan discussed his concerns regarding the likelihood of the video still existing, the motion to recover costs is denied. And pulling away from her decision, I did bring that up during my video yesterday. And again, that was before Judge Bev made her decision. I brought up the fact that when Judge Bev asks Alan Jackson, did that conversation ever take place? The conversation where Alan Jackson and Hank Brennan agreed that both of them were unsure that there would still be footage in the DVR system. Judge Bev asked Alan Jackson if that conversation actually took place. And Alan Jackson's response to her was, who cares? And and I get Alan Jackson's point because overall they should have preserved everything anyway, period, right? But when the judge is asking you if that conversation actually took place, she's asking you that question because it is a mitigating factor. Okay? Like the civil issue I brought up in a couple videos is the civil issue called detrimental reliance, in that the defense team is claiming that they had a detrimental reliance on Hank Brennan's ability to accommodate them, to accommodate their expert at the Canton Police Department so that they can just send their expert out there and he would be all set up and the Canton PD would be prepared for him to receive him, you know, and the DVR expert would be able to analyze what he's got to analyze and head back home, you know. But that wasn't able to happen according to the defense because Hank Brennan didn't make sure that there was still footage in the DVR system. But if Hank Brennan's response is, we had a conversation, Alan Jackson and I, and we both agreed that neither of us were sure that there was still footage in the DVR system, then that is a mitigating factor. That it's not so much detrimental reliance anymore if both Alan Jackson and Hank Brennan are aware that the likelihood of footage still being in the DVR system is unknown. As I said in the previous video, Alan Jackson should have had someone from Massachusetts, someone local to Canton, go to the Canton PD, look at the DVR system, and confirm with Alan Jackson whether there is or is not still footage in the DVR system or backed up somewhere. And because Alan Jackson failed to do that, that was a mitigating factor that he failed to do. It's not detrimental reliance, okay? To me, it's a civil perspective here, not really a criminal perspective. And again, Hank Brennan gave Judge Bev an out. And because Alan Jackson said, who cares, rather than saying, that conversation never took place, Your Honor. Your Honor, I never told Hank Brennan that I didn't know what was in the DVR system. Or Hank Brennan never told me he didn't know if there was still footage in the DVR system. Alan Jackson didn't say either of those things. Alan Jackson said it took place or who cares? Because it's still their responsibility to preserve the evidence. But that's a separate issue. You see, yes, the Commonwealth has the responsibility to preserve all evidence in their case against Karen Read. It's solely on the prosecution to preserve that evidence. But that's a separate issue, because the point is that the defense sent out their expert from Arizona to Massachusetts. The defense knew that it would be costly for Karen Read, and sure enough, it was over $12,000 for Karen Read to do this. And the defense did not make sure that the trip would not be futile. Okay? To me, it's a perfectly rational legal argument that if you know this is going to cost your client, Karen Read, then you should make sure that before you send out your expert from Arizona, that his trip isn't going to be in vain. Or as Alan Jackson put it, a fool's errand, you know? It's like, I get it, and I hope you guys get it too, you know? And if you follow enough court cases, arguments like this, you know, you just pick them up after a while, it all starts to make sense. You know, Judge Bev doesn't really care about Karen Read. That's well established. All you have to do is watch the first trial to know that. So if you're asking Judge Bev to give Karen Read back the $12,000 plus that she spent to have the expert fly out from Arizona to Massachusetts, Judge Bev is going to look at everything you could have done to prevent those expenses in the first place. And that's what she did in this instance. Okay, continuing with the decision. Further, though Attorney Jackson argued for sanctions for an alleged violation of Mass Art Crim Rule 14, there is nothing in the written pleading raising this argument, and the issue is therefore not correctly before the court. And guys, I did bring this up in my video. I did. And again, it was before Judge Bev made her decision, you know? And guys, that's, again, if you watch enough court cases, you can learn to discern between the nuances in these cases. You guys know that I am for Karen Read's freedom here. I am for justice for John O'Keefe and free Turtle Boy. I'm for all of that. But I'm also aware that it's important to remain objective, and that the defense, to me, should have had a more solid motion. They should have had a more solid motion to recover expert expenses, you know, and to me, they did not. And Alan Jackson's attempt during court yesterday to cite an argument, a legal argument that he did not include in his motion to recover expert expenses. I said it in my video yesterday. Usually when it's like that, it gets denied, or usually when you are adding arguments the day of your hearing that you did not include in your motion, you're giving the judge an opportunity to deny your motion. You know, you have to stick with the arguments you declared in your motion. If you don't, the judge can throw your argument out, you know? And unfortunately, Alan Jackson, with all his experience, you know, he's an excellent attorney. This to me was a mishap on his part, you know, almost like he knew better. And I say that objectively, I say that respectfully. I agree that Karen Read is owed those expenses from the Commonwealth, because I do not trust Hank Brennan. You know, I do not trust Hank Brennan has any integrity. And part of me does feel, even despite all of these facts being unveiled during yesterday's hearing, I do partly feel like this was malicious on the Commonwealth's part. They don't care if Karen Read spends over $12,000, you know? The more broke she is, the better off the prosecution is, you know, because you need money to defend yourself against the prosecution, you know? And so if you run out of money, you run out of your ability to defend yourself with excellent attorneys. So I'm saying, like, this is all in the prosecution's favor. The fact that the expert went to Massachusetts and that entire plan fell through and it cost Karen Read over $12,000 is in the prosecution's favor. It's like a win-win. They get to hit Karen Read financially where it hurts, and they get to play stupid. Like, they get to put the onus on the defense. And in this part of the sentence, in the last paragraph, the part where she writes, "There is nothing in the written pleading raising this argument," what she means by written pleading is the motion. There is nothing in the motion raising the argument that there is a violation of Massachusetts Rules of Criminal Procedure 14. So when Hank Brennan yesterday during the motions hearing, when he said that the defense should file a separate motion, he was correct. That if the defense wants to argue that the prosecution violated Rule 14 or committed Brady violations, that needs to be either included in the motion to recover expert expenses, or it needs to be a separate motion altogether. And neither of those happened. And I hope this all makes sense to you guys, okay? I am in no way defending the Commonwealth, and I am in no way defending Judge Bev. I am saying this from a legal perspective, an objective, like, technical perspective, that this was an out. Both of those arguments were an out for Judge Bev, and she took both exits. You know, she denied the motion to recover expert expenses because of both reasons. The fact that the defense, Alan Jackson, did not deny that the conversation with Hank Brennan took place, in which both Hank Brennan and Alan Jackson were unsure. They were doubtful of any footage still being in the DVR system. And the second reason, that Alan Jackson brought up a Rule 14 violation during the motions hearing, but he did not include that Rule 14 violation in the motion to recover expert expenses. So I'm just saying, guys, from a technical, legal perspective, that's why Judge Bev denied the motion. She's corrupt anyway. Hank Brennan is corrupt anyway. But in this instance, I'm afraid that the defense's motion was just not strong enough. You know, it wasn't strong enough. And I still say Alan Jackson, David Unetti, Robert Alessi, if he's still going to be part of the team, and Elizabeth Little, they should all file a strong, like, killer, like Terminator kind of motion about all the Brady violations in this case. They absolutely should. They should file a motion under the violation of Rule 14, also the Brady violations, and they should list all of them, and they should provide proof that each and every one of them took place, and that should be an entirely separate, like, domino kind of motion that they file before the retrial begins. You know, because there's no denying at this point that there were Brady violations committed. It's simply a matter, guys, it is simply a matter of the defense filing the proper motion and having it be a solid dynamite kind of motion that, like, knocks the prosecution out, you know? And Judge Bev can deny that motion too. But then the defense can take it up to the Supreme Court, you know? I'm just saying, there are absolutely Brady violations that the prosecution committed against Karen Read. Multiple, since 2022 until now. And they are all provable. So I'm saying the defense should not give up. They did not win in this instance. Right here it reads, order, defendant's motion to recover expert-related expenses is hereby denied. Judge Bev signed it February 6, 2025. It was almost immediately after the motions hearing. She didn't waste any time. So the defense lost with this motion, but I still say it doesn't mean they've lost the argument. They still have a solid argument that they can take all the way to the Supreme Court if they want to, and really expose this corrupt prosecution if they want to, and I really hope they do. But anyway, if anyone has any questions, feel free to leave your questions in the comment section below, and I will answer them as best as I can. I hope I made sense, but if I didn't, please let me know. And guys, if I ever misspeak or if I ever state a fact during my videos that is incorrect or you have more information about it, feel free to comment and correct me. I will usually pin the comments that are correcting me, or I will pin my own comment and correct myself. And I did that in yesterday's video. I provided a correction. And I hope that with this video, it's all been clarified. I also want to say, guys, that yesterday, the Free Karen Read group on Facebook, it raised, the goal was to cover the expert expenses for Karen Read despite Judge Bev denying the motion. Like, as soon as the denial came through, a post was made in the Free Karen Read group on Facebook. And guys, within 6 hours, the Free Karen Read community in that group raised $13,000. Okay? So there is a happy ending here, that even though Judge Bev denied the defense's motion to recover expert expenses, the Free Karen Read community on Facebook pulled through, and $13,000 were raised for Karen Read. So her expert expenses are in fact covered after all. Happy ending. Thank you for watching.